Hey, it's Sam with Mesa, and in this video, I want to talk to you about the return of a tenant's security deposit in California. There is so much confusion around this particular law. We have a page on our website that talks about how to return a security deposit, and it goes into quite a bit of detail. And here's a little inside baseball. That is the most trafficked page on our website month after month after month. So a lot of people clearly have questions on this. They're hitting that page, they're looking for information. So hopefully this video can be of a resource as well in that area. You have to know the law when it comes to returning a security deposit. All of this is governed by law. And so as I say that, I will also say nothing in this video is meant to be taken as legal advice. You should consult a qualified real estate attorney for any specific questions that you have about any law that I mentioned in this video or your specific situation. So with that being said, Civil Code 1950.5 is very detailed, and this is what governs the return of a security deposit. How long do you have? What do you do if you can't get it done in the amount of time that the law gives you? How do you handle wear and tear? What is clean? What is not clean? What method must you return the deposit in? All of these types of questions are answered by Civil Code 1950.5. So you need to understand that. But with that being said, let me give you 5 considerations for returning a tenant security deposit in California. First consideration, set yourself up for success. You got to go back in time if you haven't done this, which is not possible, but hopefully you're not in this position. You need to have a move-in inspection and a move-out inspection, and you need to be able to say this was the condition. It's objective. You signed for it, tenant. This is what it was. Here's the pictures. Here's the proof. If you don't have that, good luck. It's going to be difficult to charge out of a deposit because you have no way to prove that that's the way that it was. Second consideration, you need to return that deposit within 21 days. As of the recording of this video in 2024, the law says 21 days is how long you have to return that deposit. Do not miss that deadline. If you cannot do it within 21 days, the law tells you what you can do. It's called a good faith estimate, and you still have to return the portion that you don't think you're going to need, but you got to know 21 days. These are not weekdays or anything like that. These are calendar days from when your tenant moves out. You've got to get the portion that's being returned to them back to them within 21 days. Third consideration is you need to give the tenant a copy of all of the invoices that you received from any vendor that you hired to do work on the property that you are then wanting to charge them for. Whether that's all of that work or some of that work, they need to get a copy of that invoice that shows who did the work and the contact information, as well as the address of the person who was responsible for doing the work. But you have to itemize everything that you're charging tenants for. Fourth consideration is you should deduct fairly from the deposit. This is common sense, or so you would think. I've had a lot of conversations with folks that this isn't really how they see the world, but you shouldn't charge tenants for things that they didn't break. It's as simple as that. You shouldn't charge them for things that were there when they moved in. This is why a move-in inspection is also important. It's not just so that you can make sure that you're charging for everything that you possibly can. It's also to document anything that wasn't 100% working or perfect when they moved in. So because you might forget after 5 years and go, man, I feel like they broke that and I'm going to charge them for it. Well, now you're not being malicious, but you are not being fair because it was like that already and you didn't document it. And so now you're trying to charge for it. That's not good. You don't want to do that. So make sure that you're deducting fairly, only charging for things that you're legally allowed to charge for and that they weren't already like that when the tenant moved in. Fifth consideration is to consider wear and tear and useful life. Every single item in a rental property has useful life. The paint has useful life. The carpet has useful life. You have to understand what that means because you can't put new carpet in a rental property, move a tenant in, tenant stays for 5 years, they move out, carpet is worn and dirty and torn, and you go, well, I'm just going to charge my tenant for 100% of the cost of replacing the carpet. That's not only ethically wrong, that's illegal. You can't do that. You have to take wear and tear and useful life into consideration. Now, if that carpet had a useful life of, say, 7 years and it's completely trashed, it cannot be saved after a 5-year tenancy, you certainly can charge for a portion of that carpet replacement, but you can't charge for all of it. So take wear and tear into account. Hope you found this helpful. The deposit is the #1 place where landlords get sued. So you want to make sure that you're doing this correctly, that you're doing it fairly. And that way, if you do find yourself at odds with a tenant and just on different pages as far as what was fair, you can go back to an objective standard. This is why we charge. Here's my move in. Here's my move out. This is how it was. This is wear and tear. I took it into consideration. I've given you the invoices. I'm not being unfair in any way. And if you do that, you still might get sued, but at least you're in a better place to defend yourself and to sleep good at night, knowing that you did the right thing and you weren't trying to rip anybody off, especially a tenant. Hope you found that helpful for how to charge from a tenant's security deposit. Feel free to look around the rest of our website for more helpful resources on how to be a great landlord.